Join us every Wednesday for InFocus, a weekly talk show produced by the SKNIS Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.
I'm Ian Richards, welcoming you to InFocus, a weekly program where we take a closer look at what's happening within and across the government of St. Kitts and Nevis, your government. Since taking office in September 2023, Adlai Smith, the Director of Public Prosecutions, has been a strong advocate for criminal justice reform, pushing for transparency, accountability, and meaningful change within our legal system. But recently, we've witnessed a troubling development, the arrest of a Crown Counsel prosecutor that sent shockwaves throughout the community. Today, we are joined by DPP Smith to discuss this development, what it means for the criminal justice system, and how reforms are still progressing despite the challenges. Stay with us for InFocus, your government, your business.
The judge-only trial. That is a significant step by the government in regards to crime and security. So far, we have had one conviction with regard to that piece of legislation. We also want to thank the government for making the amendment with regard to the witness interference legislation.
Thanks for staying with us, and we are pleased to have back with us on InFocus, Director of Public Prosecution, Mr. Adlai Smith. Mr. Smith, you are no stranger. You are a regular person that comes every time we call, and we appreciate you being with us here for this edition of InFocus.
I appreciate that. Good afternoon to the Federation of St. Kitts and Nevis, and further afield, and anybody else from the wider Caribbean who's watching.
Right. So persons listening to this program, sir, would have just heard during our break a voice, and persons watching would recognize it as the Commissioner of Police, Mr. James Sutton. Now, he was on the program last week with members of the High Command, and he mentioned that there are two recent legislative developments that has really enhanced the criminal justice system and helping the police to complete their work. That would be witness tampering and also the judge-only trials. Now, these are two pieces of amendments that you pushed for, reforms that needed to take place. Give us a sense, sir, of where the criminal justice reform activities are, the process here in St. Kitts and Nevis.
Wow, I wonder if a whole hour would be sufficient for all of this. But some time ago, I appeared with the Attorney General to speak about different aspects of reform, and among those things we discussed was the Voluntary Bill of Indictment Act, a matter where we can bring people who are charged with offenses, serious offenses, before the court rather quickly by sidestepping what is called the committal process in the Magistrates Court. And we already have our first matter by Voluntary Bill of Indictment, which is a firearms matter, which should be coming up shortly. Because I've taken a very firm stance this year, given the high incidence of firearm offenses in the country, that all firearm offenses are going to be tried before the High Court. I'm going to bring them up by Voluntary Bill of Indictment. You're taking a chance if you have a firearm in these times. So that's one. The other one is the the judge-alone legislation. Right, and both of these pieces of legislation I really pushed for, because I thought to assist the criminal justice process here, they were necessary. The first judge-alone trial took place last December, and it resulted in a conviction. Mm-hmm. I think some other time we will be able to talk about judge-alone legislation, because I think it's an important topic, and I want the persons to understand what is the reasoning behind having judge-alone trials, and so on and so forth. And with respect to the rest of criminal justice reforms, I mean, I have a whole list of them. right? I just want to make sure. But I think that they're quite exciting, to be quite honest. We're looking at things like the vulnerable witnesses legislation. And what do I mean by vulnerable witnesses legislation? I'm thinking a little too fast ahead of myself here. When you have cases involving children, we want the court to be able to have special measures. I'm using children as an example, but it could be persons who have mental disabilities or persons who are particularly scared and so on. The whole idea is to make witnesses comfortable when they're giving evidence before the court, because we want to ensure that they're in the best frame of mind. So we have measures that can be taken by the court, like, for example, put them behind a screen so that the accused can't see them. For persons who are particularly shy and so on, they're able to give the evidence to an intermediary. Intermediary is not really somebody who's supposed to be a guide or to give them hints as to what to say or anything. That person assists the court in understanding what that vulnerable person is saying. Right? And I think that's just some of the measures. And I think those things are important, especially in a society such as ours, because a lot of time people are scared. Right? I don't want a situation where, if, for example, any child has to come to court, or any lady who is afraid of confronting, somebody who is alleged to have raped them, they shouldn't have to look into the face of the accused. You should be able to give your evidence from behind the screen. So that's just an example of another one. Another one which I find particularly exciting is the Victim and Witness Welfare Act. So much times we're talking about the rights of accused persons and so on and so forth. But what about the victims? The victim don't have rights too? They don't have feelings? Sorry, I just went into the dialect there just a little bit. So the whole idea is to provide a system whereby, if you are a witness or a complainant in the matter, a system whereby you can get to know what exactly is happening with your matter, and to put systems in place to ensure that the court has to take into account your interests when it's setting down trials and so on. Not just has to follow what you say,
right,
but basically the whole idea is take into account the feelings and the interests of witnesses and victims and so on. That's another exciting one. The criminal damage bill. Last year, December, was just completed probably the longest trial in St. Kitts history. This had to do with somebody who blew up, he tried to blow up Sol compound with all the gas and so on there, and the COSCAB compound, by setting fire to the flammable devices or the flammable storage systems over there, right? I mean, he was convicted. But you see, because the legislation is so outdated, the maximum he could get on either offense is just 5 years. 5 years. So, over my vacation, because I got my first vacation last December, I took a part of it to put together a new criminal damage bill to modernize your legislation. And I prepared that, and that's going to go before the AG shortly. The cautions bill, that's already drafted as well. I did that since last summer. I submitted it to the AG. Killing him with legislation, because I think these things need to happen. And the whole idea behind a caution, the fundamental principle, not everything need to go before the court. I mean, I listened to my Crown Counsel sometime last year, and he was telling me that he's doing a matter in the magistrate's court where somebody wet down somebody with a hose. I said, wait, hold on. Really, these are the kinds of matters which are going before the court? So the whole idea behind cautions, it's an out-of-court disposal whereby once a person admits to the offense, he's given a written caution with conditions that you have to abide by. You have to be on a set of good behavior for a certain number of years, right? And if you fail to abide by that, you're brought back before the court, you're sentenced on that, plus the additional offense, right? But if you remain of good behavior, then after a particular period of time passes, maybe 2 years or so, then it disappears off your record. And I want to deal with low-level offending insofar as less serious offenses and less serious forms of committing serious offending to deal with cautions, because I need to find a strategy to deal with the backlog in the system. And by this way, putting this into effect in the High Court and the Magistrates Court, I can free up the court to deal with more serious matters.
Right.
Right?
And that
So-
actually was the next question that I had for you in terms of dealing with the backlog of cases, because of course it was a major concern when you took office.
Yes.
That there were so many cases that needed to be tried. What has been done to help speed it up? And one of the things that, as the commissioner mentioned last week, as I mentioned, was that the judge-only trials have helped with that as well.
Yes, you see, the beauty of judge-alone trials, and I say we're going to have a special session to deal with this. The beauty of the judge-alone trials is that the judge gets to focus only on the matters which are an issue. So you don't have to go through all the evidence which would normally go through in another court. I mean, it can be agreed, but the judge now has to determine what really is an issue in this case. The issue may be whether somebody was driving dangerously, or whether somebody used unreasonable force in self-defense. Just one issue. And as a result of that, that curtailment in terms of, time and energy and so on, and because jury trials normally involve a set of time impaneling the jury, and sometimes you have to go in and out because there have to be arguments in the absence of the jury. You save a lot of time. As a matter of fact, the first judge-alone trial took place in Trinidad. A friend of mine, a colleague of mine in law school, she was the judge dealing with that, and the first trial had finished in 20 minutes.
How long ago was that?
Oh, boy. Probably, I think within the last 3 or 4 years.
Okay.
Right, something like that, because they had just introduced judge-alone trials over there.
So it's new to the region. It's a new phenomenon to the region.
Well, I wouldn't say it's new to the region, because other countries have had judge-alone legislation. I think the Belize, I know for certain. Well, we already know Trinidad, and I think Turks and Caicos had judge-alone legislation. It's not a new phenomenon at all, and it's a mode of trial which is seen as fair. I mean, not everybody going to agree with that, but then not everybody agrees with the justice system. Difference of opinion make a horse race.
The point that was raised by the deputy commissioner at that time is that the alleged persons, their rights are still protected under judge-alone trials.
Yes, and you're given additional protections under the governor general. The added advantage of a judge-alone trial. I mean, imagine if somebody, let's say for example, you have capital murder. Capital murder is, death penalty type offense. There you could get the death penalty. And let's say you are convicted by a jury. Remember, a jury don't have to give you no reason why they come to their decision,
Mm-hmm.
With a judge-alone trial, a judge gives you step-by-step reasoning as to how he came to his decision. And I think facing a penalty for a serious offense, I don't know about you, but I want to see the reasons for my decision.
That may help with the appeal.
Right, it could help with the appeal too. Was the judge unreasonable in terms of coming to this particular conclusion, and all kinds of different things, right? So, I mean, I know it's a new thing. It's when it comes to change, there's normally a bit of pushback and so on, but in time we'll see how it goes. And when we have the discussion on judge-alone trials, I will go through the judgment of the judge, and so you can see exactly what I'm saying.
Right. Okay, so in terms of the backlog of cases, what would you say? How things have been proceeding there?
Okay. Now, you see, because of the voluntary bill of indictment act, if I can bring matters up quickly, because I'm also using that for example, let's say we have a really serious murder, a firearm murder. I want those kinds of matters to be brought up within 2 years, right? And the voluntary bill can help me with that. Right? But you see, the thing is, with voluntary bill, it's making more matters come up a lot quicker before the court. So I might eventually start having a backlog at the High Court. Mm-hmm. So what we are looking at is seeing how we can incorporate the Nevis judge when he's not doing matters in the Nevis court to assist with matters in the St. Kitts court. So we have an aggressive tackling of the backlog in the system. And you see, like I said, things like voluntary bill, the cautions legislation can assist with that. Aggressive case management in terms of managing cases before they come to trial to narrow down the issues so that we save time and only focus on the issues and not things which are not disagreed on, so to speak. So that's an example of the strategy that we are using to deal with the backlog. I want to mention, I know I have plenty lorry farm initiatives, but I want to mention one particular one, the Road Traffic Offences Amendment Bill. I mean, I've been pushing for that. I understand that it's been talked about a lot, even before, like the penalties for causing death by dangerous driving. Over my vacation last December, I went through the act, and I amended all the different sections and so on, and the penalties for causing death by dangerous driving. Well, I discussed this with my assistant DPPs, and they had said, we had all agreed, increase to 15 years from 3 to careless driving and 25 years for causing death by dangerous driving. But I see the AG's office decided to increase 3 to 6, and the causing death by dangerous driving maximum penalty from 5 to 10.
Well, it's what's proposed. It's proposed in the legislation that actually will be debated on Thursday.
Yes. But we want to see stiff penalties for that, because there are a lot of accidents. The Commissioner of Police, he briefs me on a daily basis as to the state of crime in the country, and I can see that there are a lot of accidents, and there needs to be an aggressive approach taken by the prosecution to these things, because the safety of the Federation is at stake. I'm sorry. But excitingly, I thought over the vacation, why not involve the public insofar as the administration of justice is concerned with respect to careless driving? And so I propose a solution whereby persons can now install their 4K, because we need high definition 4K cameras in their vehicles, their dash cams, right? And as they're driving, they can record instances of careless driving. And you can submit these recordings to the police or the prosecution department. And if they are instrumental in getting a conviction for infractionists, that's the word I made up, but perpetrators, you can get, initially I'd propose up to $500 in my draft bill, but I see the AG's office increased it to $5,000. Well, it is, but an opportunity to make money. And I know a lot of people are afraid to give evidence in court with these matters. So I put inside the bill provisions for anonymity of individuals who don't want to do that. So once certain conditions are satisfied, you give your thing and so on. If the person's found guilty, the court gives awards a reward incentive of up to $5,000. The defendant has to pay that as part of the fee. And this is one creative way. I want to have the citizenry involved, everybody involved in enforcing the laws of our country, because it is important.
Yes, of course. And one of the things the Commissioner also mentioned was the Witness Tampering Act. And that deals with, it's a very broad subject, but has there been anyone charged under that as yet?
There hasn't been anyone charged as yet, but it doesn't mean there isn't going to be. That's all I'll say on that.
Okay.
Next question.
Right. So the next question, sir, would be, of course, the ethical standards within the DPP's office. And it's going to be quite a lengthy discussions, and we certainly would like the public to weigh in if they have their questions or comments they'd like to leave on that. And so we'll give them an opportunity to do so. They can give us a call at 466-2666, or they can send a WhatsApp to 662-3447. And we're asking persons to go ahead and to give either their first or last name and state their questions, so that we can facilitate a easy transfer of information when it's time for us to take calls. So we're going to take our first break, DPP, and then we're going to come back and talk a bit about the office and as you mentioned, the recent development with regard to a Crown Counsel prosecutor.
Can we do one word of caution?
What's that?
I'm not going to discuss the facts of the case.
Of course, of
All
course.
Right, because it's before the court. Okay.
Right, okay. So we'll take our first break and we'll be right back with more In Focus.
If you haven't done it as yet, please do it today. Subscribe to our YouTube page at SKNIS Media for regular updates, live coverage, and even more information on your government. While you're at it, like, share, and interact with our Facebook and Instagram pages at SKNIS Media and SKNIS Info.
Our discussions with Mr. Adlai Smith, the Director of Public Prosecutions here in St. Kitts and Nevis. So, Mr. Smith, as we speak about having high ethical standards in public office, what steps are in place to ensure that members of the staff in the Director of Public Prosecutions Office has the highest standard of ethical conduct?
Okay. Well, let me start first by saying that one of the things I realize in our department is that there are not any written guidelines, not any written protocols or anything like that. I mean, my staff knows that I've sought to change that. And the whole idea behind having written documents is to ensure that we have uniformity and stability in terms of dealing with particular matters, right? Like, for example, I have protocols dealing with the management of cases before the court. How do we record information in relation to matters and so on. We have conflict of interest policy and so on in place, or protocol rather, and other things, just to give you an example. One of the things I've been working on since last year was a prosecutor's code of conduct, which would address ethical standards of a prosecutor. It's a lengthy document. I have been trying to pattern one similar to the Prosecutor Code of Conduct in Jamaica, except that I wanted to update it to reflect modern changes in the law. I think theirs is over 10 years old, but the law has changed a lot since 10 years old.
And of course the realities here in St. Kitts and Nevis are different in terms of Jamaica as well.
Right. So that is something I'm currently working on to complete. And I would make that a formal document to be made a part of our office library. And I will make it a document that's available to the public as well. Because inside of that document, it will show the considerations that a prosecutor takes into account when deciding whether to charge an individual. There's a two-stage step involved in that. You have to look at the quality of the evidence and determine, looking at all the evidence and so on, can we say that there's a reasonable prospect of a conviction if we take it to trial? And then after determining that, the next stage of the process is it in the public interest to bring this matter before the court? Public interest considers things like the amount of resources available, the type of matter being brought. Let me give you a quick example of what I mean. Let's say somebody stole something from a store, but the value of the thing is just $2. Do I waste thousands of dollars of court resources to prosecute somebody for $2? Mm-hmm. That's an example of showing whether something is in the public interest. So that is really, to answer your question, short and simple, getting a prosecutor's code of conduct finished as soon as possible. I haven't gotten as far as where I would like to have reached with it, but given the circumstances, it is imperative that I move sooner rather than later with that concern.
Now, there was a recent announcement by the Royal St. Christopher and Nevis Police Force that indicated that Chantrice Dorset, a Crown Counsel prosecutor, was hit with 6 serious criminal charges, including 1 count of accessory after the fact to murder and 1 count of misconduct in public office. You made a public statement about the arrest. Why did you feel it was necessary to make a statement?
Okay. Now, number one, I want to bring a new approach with respect to how to deal with matters here in the justice system in St. Kitts and Nevis. As you noted, I've been here, actually I started in October 6th of October 6th, 2023. That's when I took up the office of Director of Public Prosecutions. And trust me, it was like baptism by fire. But I said, I have a mission in terms of trying to transform the system so that St. Kitts and Nevis can be a beacon for the rest of the Caribbean. So when we are looking at this particular matter, when it comes to Ms. Dorset, I anticipated that it was going to have regional implications. It was probably going to be profound, precedent set, never seen before. And so I thought it was necessary I started writing the press release even before the charges, but I had to update it every now and then as things were happening, because I said, you know, I'm going to need to. And of course it was brought to my attention that, you know, certain comments were circulating in the social media, and I thought it was important to address those concerns, right? Also, a case, Boudram, and let's call it the Boudram case. I don't have to go into the full particulars. But there's a particular case from the Privy Council which says the DPP has a role of being vigilant to make sure that he controls what type of information is going on in the media in advance of the trial. I mean, I don't have to respond to every single allegation or frivolous allegations or trivial allegations and so on. But once there is a serious risk that trial by jury will turn into trial by media, and this was said in 1996, so I have to update that and say trial by social media, right. The DPP has a duty to step in. And realizing that is why I did what I did. I mean, like, there were some other reasons too, but I thought that was important.
No, there were some persons who expressed concern. As you imagine, there would have been pushback on social media, as you mentioned, about the original statements that was made. Is there anything that you care to clarify at this point? Okay. Well, I have a updated press statement to deal with that. But in summary, because we don't have a lot of time, and that will come out in due course, right? I want to keep the thing simple, right? I want to put the whole thing in context. Section 10.1 of the St. Kitts and Nevis Constitution says that a person charged with a criminal offense is entitled to a fair trial by an independent and impartial court. Jurors in a jury trial form part of that court. They're judges of the facts. When you put information which prejudices or poisons the minds of people who potentially may be part of that jury, then you're infringing on that person's right to a fair trial, right? So, speculation, I say speculation as to guilt. Speculation as to guilt is wrong, and so on. You should not do that. Speculation, as long as it interferes with the right of a person to a fair trial, it is wrong. And I've addressed some issues in my press release, but maybe I can deal with them quickly, just to give some examples as to what is impermissible. Speculating as to guilt, I already spoke about that. Things like saying, oh, well, they must have done it because they were charged. Why else would they be charged? Don't speculate as to guilt, number one. 2, sharing unverified information. Like, for example, publishing rumors or unconfirmed details about a case as to what evidence you think might be involved in the case. That is not permissible. Also, highlighting bad character. Right? If a person has been behaving badly and you're posting about that in social media, that can poison the mind of the jury. Because remember, in the court, a person is presumed innocent until proven guilty. He's entitled to that bad character, subject to certain legal exceptions, but he's entitled to that, to be treated as a person of good character, before the jury. And then the evidence is led by the prosecution to show that, yeah, he's a bad character, leading to his conviction. Also, publishing sensitive details about a case. Example, sharing photos, videos, or information that is part of the evidence but it has not been made public before the court. That is not permissible. Also, criticizing witnesses, suggesting that potential witnesses in the case ought not to be believed long before the trial. That has an effect of poisoning or affecting the fairness of the trial. So, when I said what was not permissible, oh Lord Jack, I don't want to interfere with free speech. Remember last November when I had my interview along with Justice Morley, we were talking about the sentencing guidelines. I made reference to the case of Ambad and the Attorney General of Trinidad and Tobago, where the Privy Council in that said justice is not a cloistered virtue. In other words, it's not sheltered, right? But however, justice must be allowed to undergo the scrutiny and the comments
even outspoken comments of the ordinary man out there. And that principle remains fundamental to my understanding of the thing. But like I said, the Privy Council also say that I, as the DPP, have a role to make sure that there's no adverse pre-trial publicity. And I can go before the court, ask for an order. Anybody chat after that is contempt of court, right? But I don't want to have to do that. I'm just trying to follow the law. And remember, I'm trying to do a new and creative and vibrant way of doing things. So I'm not going to get everything perfect the first time. I just want to say something quickly about criticism. I mean, yeah, I'm subject to a lot of criticisms. But, oh gosh, man, I'm a public official. I'm supposed to accept that. I'm using this as an opportunity. I see this as an opportunity to educate the public further and to offer greater clarity. So I want to say to my critics out there, thank you very much. I've learned a lot from the experience. Keep criticizing, because the voice of the opposition is important in a democracy. I repeat, the voice of the opposition is important in a democracy. And when you continue to criticize me, you keep me on my toes. I am a public official, right? And I should be kept on my toes. Right. I don't mind that. So what you're doing is improving me, and I thank you for it earnestly from the bottom of my heart.
So you are trying to protect the integrity of a fair trial.
Of the system.
But the Mr. DPP, how does the arrest affect the work being done by the DPPO, as in the eyes of the public in particular, from that point of view?
Well, our office, I can say simply, we are on our P's and Q's. We remain focused. We have work before the court. We're continuing to do the work.
So you actually just answered the next question that I had with your previous clarification, where you spoke about ensuring that officials don't prejudice or bias in one way or another. So then I would ask then, as you speak about the fact of being able to have a public persona, so to speak, I came across an article written by Mr. Kyron Murdoch, I believe that's the name that he goes by, and it's on the website Antigua.news, and it's entitled "Enough but Not Too Much Enough." And here are some key points that I would want to mention in the article that he would have highlighted. And I'll start with the intro, where he says that we take this opportunity to commend the Director of Public Prosecutions in our neighboring country of St. Kitts and Nevis for his refreshing and forthright approach to public and media engagement. Now, he speaks about the fact that since you took office in late 2023, that there's been a certain savvy for a reasonable and measured level of communication with citizens served by the office. And then he also goes on to mention that more recently that you would have appeared addressing the controversy of a Crown Council, which is what we're discussing now, and it's not often that you find the DPP willing to communicate with the public on a steady basis. What are your thoughts on that? The fact that, you know, it's being recognized, and of course, as mentioned before previously, you came to St. Kitts and Nevis from Antigua, where you worked within the criminal justice system there as well.
I'm extremely humbled by that, and if this is permissible, whether permissible or not, I give thanks to Almighty God, right? Because He has been downloading certain things in my spirit with respect to how I can reform the justice system here, and I see, yes, some of them are working, some of them are well received. There's still some criticism, but that's okay. At the end of the day, let me tell you something. As long as I'm DPP here, my interests, primary interests, are those of the Federation of St. Kitts and Nevis. And what I want to see is that our justice system becomes one that other jurisdictions can follow. We are a small federation of people, St. Kitts and Nevis. How much people we have? About 40,000, 60,000?
51,000,
51?
actually, yes.
All right, in between, all right, fair enough. 51, we're small, but we're Talawa, right? We have the eyes of the Caribbean on us right now, and we have an example to show them how our justice system can work, how we can see corruption, but we don't cover it up, right? We deal with it as necessary, and we deal with it hard as well too. And it's not necessarily going to be limited to Ms. Dorset. Matters going forward and so on, they will be dealt with firmly once there is the evidence, because you have to have evidence. You can't bring somebody before the court based on speculation or hearsay.
Now, the topic also was discussed on a news program in Antigua. It's a talk program, really, and they noted that a precedent is being set in the region by a case of this high-profile nature going forward. What are your thoughts there as well?
I had opportunity to listen to again, I'm humbled by their comments because they lauded the approach that I took in relation to this particular matter. And dare I say, I've received a lot of commendation from senior legal luminaries, court officials around the court for this. And I'm happy for that because it shows St. Kitts and Nevis in a very, very positive light. That's what I want to see for St. Kitts and Nevis. Let us be the best at something. That's all I want, right? And I'm trying my best to achieve that. And all I'm asking is, oh man, just the rest of the population, just give me a chance to make it happen. Work along with me. Work with me, man. Work along with me and let's put country above self and make it happen. That's all I'm asking, right? But insofar as the commenters on the program are concerned, right? We already established that this is of presidential nature, right? Going forward, as I said before, we need to show and be vigilant, especially with respect to the handling of this matter, because the region is watching us. The other issue I wanted to raise, where I said that it hasn't been raised as yet, but even Friday, after I issued the press release, I had a conversation with a senior prosecutor, and we were even talking about recommending to the AG having a special prosecutor assigned to the matter. And why is that? I mean, let's say for argument's sake, yes, you can see I have a robust approach to prosecuting corruption. All right, but think about this. We're talking about someone who has been at my side in cases, somebody who has advised me in matters. Consider this. If I prosecute the matter and the matter ends up in acquittal, what do you think the public going to say? Boy, he engineered it. Corruption, cover up, he deliberately lose the case. I'm talking about how people will say, right? So, and of course, remember I said I have a conflict of interest policy. So if there is, for some reason, why there's something inside of you that would affect you from bringing your proper judgment to the prosecution of the matter, you should recuse yourself. So one of the necessary steps in this matter to be taken further down the road is to have a special prosecutor. I have one in mind, but it's not to say that other persons can't apply. I mean, we're considering those who will do it for free first because we're trying to save the government a little money. But think about it. You're going to be part of a precedent case, which will probably be in law books for years to come, right? And look at it from that particular standpoint, and don't charge us no money, please. Yes, but the point I'm making is the importance of not only justice being done, but justice be seen to be done, and fairly done as well too. So I think the idea of having a special prosecutor, given what I just said, is important, and we're going to be looking into that.
Persons wishing to join the conversation can do so by calling 466-2666 or sending a WhatsApp to 662-3447. DPP, let me ask you then, in terms of, we established the fact that it's wide reach, and actually Primetime Caribbean is just before this program does on ZIZ television, and of course it made headlines there as well. Now, locally, persons are saying that this is a hit on the DPPO, which is your office, and legal profession as a whole. What do you say to persons aspiring to be a lawyer in the future when this type of controversy is swirling around?
All right, well, everybody knows I come from Antigua. Burning Flames has a song, one bad apple doesn't spoil the whole bunch, right? Similarly, the fact that somebody may not be living up to par doesn't mean that you shouldn't aspire to be an attorney. It's, being a lawyer is considered to be a member of an honorable profession, right? And if you want to be a lawyer, I would advise you, look, you bring your own brand of fairness to the profession, your own brand of legal expertise to it, something that will benefit the profession. That shouldn't stop you. If you want to be somebody who affects legal change in the society, nobody should be able to stop you. Just make sure you have your wits about you. You're not corrupt. And that at the end of the day, I mean, apart from the little money, money shouldn't be the primary objective why you're coming away, even though you can make plenty of money. And by the way, legal fees over here quite expensive. Mm-hmm. But the whole idea is have at your core interest or objective the pursuit of the ideals of justice and fairness. That's how I answer that.
Okay. We'll take a final break, DPP, and when we come back, we're going to speak about another subject that was very controversial and high profile in St. Kitts and Nevis, and that would be the Public Life, well, the Integrity in Public Life Act that was passed, and so we'll get an update there. Stay with us, we'll be right back with more In Focus.
If you haven't done it as yet, please do it today. Subscribe to our YouTube page at SKNIS Media for regular updates, live coverage, and even more information on your government. While you're at it, like, share, and interact with our Facebook and Instagram pages at SKNIS Media and SKNIS Info.
Welcome back to In Focus. We continue our conversation with Mr. Adlai Smith, Director of Public Prosecutions here in St. Kitts and Nevis. Mr. Smith, integrity in public life. Where are we? Can you give us an update in terms of what's been happening there?
Okay. Well, you all know that I charged a magistrate for not filing his declaration on time. And persons understandably probably know what is the result of that case. Well, it so happens that after the period expired for the filing of the second declaration, which was April 30th, some names were submitted to me. And again, the magistrate did not file. So he was charged a second time. So he currently has two matters before the court. One of the problems that has caused this matter to be delayed and being brought up before the court is that only I can deal with it. And the problem is, generally when the matter comes up for trial, I'm either in the High Court or out of the jurisdiction, and so that's caused the problem. As a matter of fact, it was supposed to come up this week, but because I'm still vigorously working along with the violent crime unit and the white-collar crime unit with respect to the current investigation, right? I've asked for, and with the concurrence of counsel on the other side, for some time to really deal with these issues because it is significant and very important. The compliance second time around was way, way better than the last time. There were some persons who were late, like a couple of days and so on after the last deadline, and there were some persons who didn't file. I just want to remind the court that it's not just a situation where you don't file and you're convicted. You have to have not filed and you don't have a reasonable excuse for not filing, right? And as I promised before, I wanted a humane approach toward dealing with the particular issue. Because mind you, I don't have to go by summons. I could simply ask the police, you deal with this. I've gotten these names from the Integrity in Public Life, right? And the police could go and apply for warrants and pick you up at your workplace or wherever you may be and take you there, right? But I said, no, let me adopt a humane approach, right? And so I took the civil approach to have an officer write to individuals explaining why you were late, right? And why you may not have filed. And persons did reply. They were appreciative for that. And I think that is civil. And of course, they came in and did their, because at the end of the day, I want St. Kitts and Nevis. St. Kitts and Nevis, like no other country in the Caribbean, and dare I say the world, we have the highest rate of compliance where that is concerned, right? And I think it has to do with the approach. So commendation to all those public servants who think. Of course, there were one or two who thought, well, oh, why should I write to them about that? Well, those individuals next time, okay, if you take that approach, I'll send the police if you don't file, right? But the whole idea is I want to be sympathetic and civil and compassionate insofar as how I exercise the function. Everything don't have to be big stick and prosecution. So that's where we are. There's one other person before the court also, I don't want to call the name, right? But the lawyer and I are speaking because there's a particular issue which has arose, and I'm considering, well, whether what he's saying could amount to a reasonable excuse, because like I said, I want to be fair. I don't want to be giving people convictions unnecessarily. But it's when you harden and you insistent and so on, that's when I'll go after you, right? And not go after you because I want to go after you, because I'm thinking I'm protecting the integrity of the system of justice of St. Kitts and Nevis, right? And I mean, who knows? Maybe there might be another charge coming. I don't know. Let's go. Next question.
Will any new categories be included or exempted from the legislation?
Well, you see, at the end of the day, that's something for the Attorney General and his government to decide. One set of recommended, well, some categories I think probably could be removed. I'm trying to think off the top of my head. I can't think off the top of my head, but who should be added? Currently, in my office, let's start. Judgment starts in the house of the DPP. It's only myself and my assistant DPPs, right, are required to file. In Antigua, all the prosecutors have to file. All my prosecutors, including myself, are susceptible to corruption and corrupt vices. So all the prosecutors in my office, to my mind, should have to declare their income and assets to the Federation. That is who I can think of off the top of my head.
Okay. Now, I want to switch a bit in terms of, we spoke a bit earlier about the traffic accidents, and I want to come back to that because, of course, it's a major concern here for persons in St. Kitts and Nevis. And we've had a number of fatal crashes and stuff, and so we would want to talk about that. And as I mentioned, last week, the Commissioner mentioned that persons have been charged for fatal crashes. And what role does your office play in deciding which cases, because I know that the police submits the evidence, that which cases that is enough to try someone or that they should be dealt with in another process?
Okay. Well, generally, that's done either by myself or one of my assistant DPPs. And let me take the opportunity to commend the hard work and support that I've received from my assistant DPPs, because to stay out of court to deal with other pressing issues, they have to be the ones to take up the slack in court. And so I want to take the opportunity to big up Mrs. Greatest Gordon Hazel and Mr. Tishawn Vasquez. I am proud of them and the efforts that they're doing. Now, to answer your question, like for example, I'm currently reviewing two. As a matter of fact, I was supposed to have meetings with the investigators in two causing death matters, one involving the good doctor who was killed in a traffic accident. They're close to the airport there. I had to, I was supposed to meet with them, I think it was Monday of last week. They were supposed to bring the files. But I had to put that aside because of other pressing matters. But I have started to consider one.
Let me stop you there, DPP, and because you said you had to put it aside for other pressing matters. It's not that you are ignoring the case file, because there's been some suggestions out there, I suppose, by persons who may not have well-intended means, but in saying that, you know, the trial essentially, or the case, the investigation, is basically being ignored by the office for whatever reason.
No, it's not being ignored by the office. Not at all. Well, let me tell you one of the factors here. Like, for example, in the instance of the doctor, let me start with this principle. You don't make a decision based on just half or 1/3 of the information. you get as much of the information as possible, and then you make the decision, right? Currently, we are still waiting for the autopsy report in relation to the cause of the death of the doctor, because I need to see what injuries she received, where she received them. I asked for information from the officer. What was the height of the vehicle which is alleged to have hit her? And I want to see if there's a correspondence between that. I've already gone to the scene, not during the day, at night, when after 10 at night, along the road. Persons this week might have wondered why there was a hold-up on the road. Yes, the Director of Public Prosecution was there, evaluating the scene, checking to see how the accident could have happened, trying to figure out how the young lady ended up in the position she ended up, and so on and so forth. And I have to look at a lot of things, testing to see, okay, can I see if some individual is crossing and so on? Because remember I said, the first part of the decision-making process is to determine if there is a reasonable prospect of conviction. So I have to look at what the accused is saying and see, well, based on what he's saying, based on me looking practically at the thing, because the court going to have to go to the scene to look for itself, can I rebut? Can I make a reasonable argument to rebut what the defense is saying? That is what I have to consider. And if I can make a reasonable argument to rebut what the defendant is saying, then he will be charged. But if I can't make a reasonable, then consistent with the decision-making process or protocol, which I've already established, I would have to decline to prosecute. But if I do decline to prosecute, rest assured, because the public is very interested in this particular case, I will be putting detailed reasons in writing so the public can have a look at it and see that I did not just make my decision on a whim. That is what I'm prepared to say on the matter.
Okay. Now, the Commissioner of Police also mentioned that there was a resource person brought in, an accident expert. Tell us how that may have factored into some of the cases that your office is being considering, especially when it comes to the fatal crashes.
All right. Well, I can say, for example, the opinion of the accident reconstruction expert was important insofar as me giving the go-ahead to charge for the gentleman who killed, I think, about 5 people in his bus. That report was very, very instrumental. But you see, we want to not build cases just on accident reconstruction experts. Let me tell you the problem I'm seeing in the Federation, right? And it goes like this. There are people who've seen, but guess what? They say they don't want to get involved. They don't want to give statement to the police. But if you were to ask those same persons, if your daughter was raped or you were robbed and somebody else saw, would you expect them to come to the court and give evidence in your favor? I don't have to give you an answer to that. The answer is obvious. So my thing is, look, do unto others as you would do for yourself. It's the same principle when it comes to social media engagement. What I'm trying to say, listen, if you're posting something on social media, you want to post something on social media, think about this. Say to yourself, 1, if I was a person on trial, would I want somebody else to say what I'm about to put about me? And if you can honestly answer that with yes, then by all means, go ahead and publish it. But if you can honestly answer no, then you should decline and refrain from publishing it. So the short point is, if you want to see cases prosecuted and prosecuted well, the people have to contribute to the system. A case is based on evidence, not speculation. I can't, as DPP, go before the judge and say, hey, judge, subject to exception, judge so-and-so say that this person did this criminal offense. And the judge put down his gavel and say guilty. No, that's not how the court works. The court based on evidence, rules of admissibility, the weight of evidence, etc., etc. And so if you want to see people brought to justice, then you, as a public citizen, you have to play your part, your role. If you see something, say something. Like I said before in a previous press release sometime last year, if it's a situation where you want anonymity, we can see if we can work out anonymity for you so that nobody know who you are based on the provisions of our anonymity legislation. Because in my mind, it's better to try something than to try nothing at all.
And of course, the Attorney General has been wanting persons to get more involved and familiar, I should say, with the whole trial aspect of it. And there's been an open move to have persons to come in to sit in the gallery and view trials. Of course, that's all legal. And is that something that you endorse?
Of course, I endorse that in appropriate cases. The problem is the St. Kitts Court, sorry, but it's like somebody's living room. It's too small. You can't have more than maybe 6 or 8 people at most in the court. And of course, there needs to be more court reporting, I feel. I think that there is a big gap in terms of information and education when it comes to what happens inside of the court. Right? And so, as DPP, I'm going to take the initiative. I'm going to have a new Crown Counsel, which is coming in shortly. I had hired her with the concurrence of the AG's office. And what is particularly interesting about her is she is interested in coming to the media, just like I am, and I want to use her to be able to talk about different topics touching and concerning the justice system, along with another counsel in my office. And what I want is for, based on what the topic is, we'll announce it well in advance. The public can submit questions via WhatsApp and so on. We vet the questions, just make sure that they're appropriate, and we will answer them on air so that the public can be educated about their justice system. I'm tired of this misinformation in the system. You know, there's some people who don't even know what the Director of Public Prosecutions is in this federation. I've seen it, right? And I say there's a need for it, and I want to help do my part in fulfilling that gap. I've spoken to one of the managers of Win FM because we're trying to see if we can get a program sponsored, or maybe we may be able to get a program on the national station. I don't know.
Yes.
But it's important.
Right. And of course, I should mention that the Sir Lee Llewellyn Moore Judicial Complex, that's under renovation, and that has a lot more space, so persons will be able to participate in viewing trials when that's completed. I'll give you an opportunity to make any final comments that you'd like.
Oh, we've come to the end already. Wow, that time flies really fast. Well, what can I say? St. Kitts and Nevis citizens and residents, we stand at the crossroads in our justice system. We can either pull together or we can continue to fight against each other. As I would have put in my second press release, which hasn't come out yet, we do ourselves no favors if we engage in a war of words against each other. A house divided against itself cannot stand. It's amazing that in 2024, I can ask Amazon Alexa to turn on my lights, my fan, my electronic devices. I can use AI to do all kinds of things on the computer. But in 2024, we can't find a meaningful way for people to have dialogue where those people have differences of opinion. That is an indictment on us as a people. For those who are interested and genuinely interested in the advancement of the justice system, I have had specially created an email address for this purpose. It is called dppfeedback@gov.kn. That is dppfeedback@gov.kn. dppfeedback.gov.kn. And that is for persons to be able to offer their comments, their feelings about the system, what they think is wrong. But when you're saying what is wrong, come with your solutions as well. And all of this has an important role to play in the reform of the justice system, because it's only he who feels it knows it. I feel it from only a standpoint as a prosecutor, but you as a member of the public might feel it a different way. I want to know what you're feeling and you're experiencing, and we'll use that to shape how we go forward in terms of how we deal with the discharge of our functions as prosecutors. Granted, don't always expect an immediate response because we have a ton of work to do.
Right, right. Director of Public Prosecutions, Mr. Adlai Smith. It's a very good point to end it on right there. And of course, we'd like to thank you for being with us for this edition of InFocus. And as you mentioned, You certainly will be back.
Yeah. Yes, I will be back. It has been an absolute pleasure.
I would like to thank you, viewers and listeners, for joining us for this edition of InFocus. We trust that you will join us next week at the same place, at the same time. For now, I'm Ian Richards. Remember, it's InFocus, your government, your business.
Join us every Wednesday for InFocus, a weekly talk show produced by the St. Kitts Nevis Information Service, where we provide exclusives with key persons within the government and discuss pertinent, relevant, and interesting matters that affect us all. Tune in every Wednesday, live on ZIZ Radio and streamed live on Facebook at SKNIS Media and ZIZ Online. InFocus, your government, your business.